The Honorable, the Supreme Court.
Good morning, everybody. Thanks very much. Please be seated. And go ahead and call the case, if you would.
Good morning, Your Honors. The matter before the court today is the case entitled Draxian Talandar versus Elizabeth Manchester Murphy, case number 24 AP 061. Representing the appellant, Draxian Talandar, is Cabot Teachout. Seated at counsel table with Attorney Teachout is Andrew Clyburn. Representing the appellee, Elizabeth Manchester Murphy, is Laura Byerly. Seated at counsel table with Attorney Byerly is Talea Barksdale.
Okay, thanks very much, and good morning again. Counsel will hear from the appellant first, of course. Come on up. Please, and if you would, for the record, introduce yourself and identify your client.
Good morning. May it please the court. My name is Cabot Teachout, and I represent the appellant, Draxian Talandar, in this case.
Thanks.
I welcome questions at any time. The central issue in this case is whether someone who has been wrongfully imprisoned for 2 years based on a false report that was made to the police has a remedy in court under our laws and under our Constitution.
You invited questions, so I'm going to ask one already. And it's based on what you just said, a false report. I'm having trouble seeing in what we have before us confirmation that this was a false report. Your client has a view, the other party has a view about the facts, and a jury had a view about the facts. So what do you base your claim that this is false, a false statement on?
Well, the standard of review at the pleading stage requires the trial court to admit and accept all statements by the non-moving party as true. In this case, that means any averments or affidavits by Mr. Talandar should have been considered true. And the standard of review also requires the court to consider any contrary assertions by the moving party as false, meaning that in this case, the trial court was required to assume that Ms. Manchester Murphy's claim that her allegations were true was a false statement. There is support in the record in the printed case, page 88, which includes what we, Mr. Talandar, asked the court to hear at a hearing on the anti-SLAPP motion. And those include Ms. Manchester Murphy's own statements to law enforcement officer, to her doctor, and 2 different law enforcement officers that the sex that she had with Mr. Talandar throughout the relationship was consensual. Then, of course, later she turns around and she tells the police that it was non-consensual, and that's the basis for Mr. Talandar's criminal case. But there is an indication in the record, not only Mr. Talandar's own statements, but her statements to law enforcement that the sex was consensual, which completely contradicted.
So, I'm sorry.
No, go ahead.
If we could talk about what happened in the criminal case for a second. The trial judge found probable cause, right?
That's right.
And also, I assume, I don't remember the record on this, but I assume in a weight of the evidence hearing, decided to hold him without bail?
That's right. That's correct.
So how are we supposed to account for that? Or are you saying that we should completely disregard it for purposes of the procedural posture of your case below before it got here?
I'm saying that you disregard any findings that were made in the criminal case. And I'm not even suggesting that somehow Mr. Talandar's acquittal in the criminal case is a finding that Ms. Manchester Murphy's were false. That finding comes from a presumption that Mr. Talandar's pleading in the civil case are true. But the standard for finding probable cause, especially in sex assault cases where it's virtually based entirely on one person's statement, sometimes there's more. There isn't in this case. But in this case, finding a probable cause based on one person's statement that says, I was a victim of sexual assault or I was a victim of domestic assault isn't really a meaningful finding. And it doesn't control the outcome of Mr. Talandar's defamation an intentional infliction of emotional distress claims in a subsequent criminal case. The only thing that it does do is preclude Mr. Talandar from being able to raise a malicious prosecution case. And that's because this court has held on several occasions that a probable cause finding by a criminal court precludes a defendant from later asserting malicious defamation claims.
So let me ask kind of a parallel question to this. It's not the same, but I think it's tangential. Are you also arguing that there's no absolute privilege for a witness to disclose X, Y, or Z in a law enforcement investigation?
I'm saying that there is no absolute privilege for a witness or you or I or anyone to go to the police and make a false report.
Is that because, and are you saying that the derivation from that is based upon the Constitution, Article 4? Is that where you get, is that what you're arguing as well?
Yes, in this case, the trial court applied this absolute privilege, extended the holding in Couture versus Traynor, and applied it in a way that has never been applied before in Vermont.
But you know,
It's made prior to any judicial proceeding being contemplated. And in doing so, it violated Mr. Talandar's right to a remedy to seek redress for the harms that he suffered under Vermont Article 4.
But Article 4 talks about recourse to the laws conformably to the law. Conformably to the law is what Article 4 of the Constitution says. So it seems to me we're not analyzing this in some vacuum, which, forgive me, I have the impression is what you want us to do. Rather, it's there is a basis that we've got to look at this through. I don't know if I'm asking a very cogent question, but
well, that's the last clause of Article 4.
Yeah,
the first
right,
clause
right.
also guarantees everyone who's
yeah,
a right to a remedy, and that's the part of Article 4 which was denied to Mr. Talandar in this case by dismissing.
but conformably to the laws is part of. It's not a separate sentence. I think it's all part of the same clause.
Well, I would suggest, Chief Justice, that applying an absolute privilege in this case to statements made before any judicial proceeding even existed or was contemplated is an extension and actually departs from what the Vermont Supreme Court has held before in Couture versus Traynor. I also want to point out, as I said in my brief, that the restatements on which the trial court relied and the restatements on which this court relied on in Couture versus Traynor has an exception, an important exception, which is that in statements that are made preliminarily before any judicial proceedings, those statements must be made in good faith. And there's actually a very helpful legal analysis in a case called Hopkins versus O'Connor, which was cited by this court in Couture, in which it was the Connecticut Supreme Court held that when statements are made in bad faith under this theory of absolute immunity, when statements are made and they are alleged to be made in bad faith with malice, they are not subject to the protection of absolute immunity, and it is for the jury to decide whether or not.
Do you make that allegation in your complaint?
Sorry?
Do you make the allegation that the statements were made in bad faith with malice in your complaint?
Oh, yes. Yeah, it's in there.
You were just talking about the right to a remedy and that your client was declined the ability to have a remedy here. Now, that was one of the constitutional issues that you raised. And the court, it seems there were 3 constitutional issues that the court never addressed. And so we have the option of ruling on them, or we have the option of remanding on them. And what are your thoughts about that?
I submit that the record in here is complete. And one of the biggest issues in this case is whether or not Vermont's iteration of the anti-SLAPP statute is constitutional. And under the precedent, which I've cited in my brief, It clearly fails the constitutional test because it deprives the fact-finding role from the jury and gives it to the trial court judge. The record is complete on that issue, and if this court rules along with the Supreme Courts of Minnesota and Washington, there's no need to remand this case back on the anti-SLAPP statute any further.
So what about the other two issues?
The other two issues, meaning the Article 4 issues and the privilege.
They are that your client was entitled to a jury and that the burden was inappropriately shifted to him, both under the SLAPP.
I think that even though a record wasn't really made, actually the trial court deprived us of an opportunity to make a record because it didn't give us a hearing. Even though a record wasn't made, you don't need to remand it back to the trial court in order to decide the constitutionality of both of those points. I see that I've reached my time limit and I'll reserve the remainder of my time.
Sure, that's fine, sure, thank you.
The questions right now.
All right, thanks very much. We'll hear from counsel for the appellee, please. And if you would, for the record, introduce yourself and identify your client. Yeah, you got, all right. We're just talking about putting a big sign on that button so that people know. Little sign,
Yeah, we
okay,
agreed on a little
sign.
sign, Chief. That was the agreement.
It'd be big from my point of view, but I'll defer to my colleagues on size of signs, that's it.
It's a pretty amazing podium.
Yeah, it is, yeah. You can drive it out of here too if you want.
Good morning, Your Honors. My name is Laura Byerly. I represent Elizabeth Manchester Murphy, the appellee in this matter, and I'm from Vermont Legal Aid.
Thank you.
Ms. Manchester Murphy truthfully reported a crime to the police. Appellant seeks $3 million in damages for making that report. Today, we ask this court to uphold the decision dismissing and striking the appellant's complaint. The alternative, permitting every criminal defendant with means to bring lawsuits against those who report crime, would have the very chilling effect on the justice system that Vermont's laws, public policy, and this court's precedent seek to prevent.
So I don't mean to interrupt you so quickly, but I have to. We have a pretty low bar in this state with respect to dismissal of complaints on motion. You would acknowledge that, I assume? Yes?
I would just ask for clarification.
Well, I think the case law, and I'm trying to remember the name of the case, so it'll come to me in a second, but the case law says that we look at the allegations in the complaint and we make a decision based upon whether or not those allegations, not some implication from those allegations, but from the allegations themselves, whether or not there's actionable redress that's available under the law. And here, Mr. Teachout has pointed out, I looked for it, but I didn't find it before, but I looked for the complaint. He tells us that the complaint alleges that the statements made by your client were made with malice. And so what we have here is a decision on a motion, effectively on a motion to dismiss. Aren't we obligated to review this decision under this law that says there's a low bar that plaintiffs have to meet in order to beat a motion to dismiss? Aren't we obligated to look at it through that, from that point of view?
Even if this court applies that standard, the plaintiff's or the appellant's complaint fails because he fails to state a claim upon which relief may be granted, because the statements made by Ms. Manchester Murphy in her police report in reporting a crime are both protected by an absolute privilege and by Vermont's anti-SLAPP statute. This court has already held that an absolute privilege applies to judicial and quasi-judicial statements, or statements in quasi-judicial proceedings, and preliminary to those as well. And a police report is as intrinsic to the judicial process as the statements to parole officers or the pleadings in a relief from abuse case were in this court's decision on Kuchar v. Trainer. Applying an absolute privilege as opposed to a qualified privilege does come with legitimate concerns about false reporting, but this court has already addressed that. This court decided that those risks are mitigated by other safeguards within our judicial system. Police reports do not become charges without investigation. That investigation can lead to those charges, and serious consequences to the report can lead to criminal charges for the reporter, and serious consequences to anyone who makes a false report if that investigation shows falsity.
But just so, I'm going to interrupt you again, just so you understand what I'm saying, make sure you address it. He's alleging in his complaint that the statements your client made were made with malice. I'm not saying he's saying it here in the context of this hearing. I'm saying it's in his complaint. Does that matter? Doesn't that matter to us?
I would say respectfully that it doesn't in this case.
So are there no statements that a client in your position could make with malice that would not be actionable?
Yes, absolutely. There are any statements made outside of reporting a crime to the police. There are a wide variety of public statements that my client or any person could be held.
So the absolute privilege applies no matter whether malice is involved or not, right?
Yes,
That's what you're saying.
and that's because it's important to allow the free reporting to police of crimes. We want people to feel free and able to report a crime to the police, and then we want the police to do their jobs and investigate those crimes thoroughly or those allegations thoroughly before the case moves on in the criminal justice process.
And aren't there protections in the system itself, such as perjury prosecution?
Absolutely. There are protections all along the way within this process that defer in a lot of ways to the rights of the defendant. And if a person does make a false report, they can be held liable for making that false report that is a criminal charge. They can also, if they continue and maintain those false reports through trial, could be prosecuted for perjury. So there are serious implications for making a false report. And false reporting actually statistically happens in this type of case at a very low rate, between 2 and 8%. So the area on this, it is such an important public policy that we allow victims of crime to reach out for redressive grievances from the police and not try to take it upon themselves.
Ms. Marie, does it matter that Mr. Teachout has pointed the court to page 88 of the printed case where Ms. Manchester Murphy had made a disclosure that the sex was consensual between herself and the appellant?
The context for that, I'm not going to go into the context for that because we don't have that before us here. But the police officers had that information at the time that this case was brought to the criminal courts. The court had, or at least Mr. Teachout had the opportunity to bring that to the court and any of the weight of the evidence hearings or any of the multiple proceedings that happened during the criminal process. And so that was considered within this case. That was not just something that, that was never brought up. It was part of this court, the trial court in the criminal cases record. And they still decided to keep this case going. And as the trial court correctly pointed out, much of the harms that Mr. Teachout or Mr. Talandar has complained about are not Ms. Manchester Murphy's responsibility. I mean, think about when this happened. This was in the middle of the pandemic. A lot of the harms that Mr. Talandar has complained about involved the delay in his case being processed. I agree that it would have been ideal to have this case processed in 60 days because he was held without bail. That's what the statute contemplates, and that's what we would like to see happen. That would have been a benefit for my client as well, who also has a speedy trial right under statute. But But that didn't happen here, and that was the situation entirely out of Ms. Manchester Murphy's, and frankly, out of the appellant's control as well. We were involved in a pandemic. So much of the harm that he is aiming at my client, for lack of a better word, is caused by circumstances entirely beyond her control.
Would we agree?
Would the situation be different if a statement was made to a police officer and the police officer determined that statement to be false? And then didn't bring the action to the state's attorney's office, didn't bring charges, just made a determination that the report of a sexual assault or a domestic assault was not legitimate? Would that create a cause of action?
No, in my opinion, the absolute privilege would still apply, because the absolute privilege doesn't look for the motivations in making the statement. It just says that this protected speech is so important, that protecting the speech and having the speech be free is more important than possibly a tort claim against the person who makes that speech in that context. But it's a very limited context. If a person was making false statements outside of the context of making a police report, those statements would absolutely be actionable.
As defamation, potentially.
As defamation, potentially, or any other cause of action that the harmed party wished to bring.
If we agree that the statements here are absolutely privileged, does that resolve all the issues in the case as far as you're concerned?
Yes, it does. Thank you, Your Honor.
What about the constitutional issues that the court didn't address? I mean, the court kind of said, well, I ruled this way, so we don't need to deal with those. And I'm not sure that's right.
Well, the constitutional issues raised by the appellant seem to stem from the idea that he has been unable to seek a particular remedy. The Constitution doesn't require that every remedy be available to every person. The legislature routinely puts limits on what kinds of cause of action can be brought. They put statutes of limitations, they put specific procedural groups in place in medical malpractice, in foreclosure, in replubbing, so that there are specific things that a plaintiff must do in order to maintain that cause of action. And because the type of speech that the legislature is trying to protect with Vermont's anti-SLAPP statute is so vital to our society, they have decided to put more onerous hoops in place that a plaintiff must go through. It doesn't mean that he's deprived of the remedy. It simply means that in order to get there, he's going to have to show that the speech was devoid of any reasonable factual basis or basis in law, and that speech actually caused him harm. So that is a high burden to put in place, but that is not inconsistent with our Constitution or with the rights of our citizens. It's saying that we're saying that this speech, this particular narrowly construed speech, is so important to the vital functioning of our society that we're going to make it just a little bit harder for somebody to sue someone for $3 million. And we recognize privileges, and we recognize these protections throughout our jurisprudence. The Supreme Court recognized the attorney-client privilege, the U.S. Supreme Court recognized the attorney-client privilege as early as 1807 in the United States versus Burr. There are privileges protect speech that is so important to being a human that we just don't allow people to sue you for that. But Mr. Talandar has may seek remedies against, possibly, I don't know, those who prosecuted him if he felt that the investigation was incomplete and improper, or perhaps there's a claim he may make against the state. But those claims do not belong here. They are not against Ms. Manchester Murphy. There's an important public policy that I've stated, but I'm going to keep stating it because it is so very important. We need people to be able to report crime to the police. We need that to happen. That is the cornerstone of our criminal justice system. If if a victim of crime, especially such an intimate crime as sexual or domestic violence, has to take into their calculus that if they make this report, they may be subject to litigation for making this report, that's going to have an extreme chilling effect on an already grossly underreported and underprosecuted crime. And it is an incredibly serious crime that has impacts that go for generations. We need people to feel free to exercise their right for redress of grievances, seek that redress from our police and from our justice systems. We need that to be something that is free and unfettered. And we need our systems to work and investigate that. And if Ms. Manchester Murphy's statements had been false, she would have been subject to possible criminal actions, possible perjury crimes. So there are other avenues to protect Mr. Talandar. And ultimately, if this was a false report, and I am not conceding in any way that it was, the system worked. He was acquitted at trial, which is what we want to happen if we cannot meet the high burden we place on victims in the criminal justice system to prove a case beyond a reasonable doubt. For those reasons, we ask this court to uphold the trial court's decision, striking and dismissing the appellant's complaint. Thank you.
All right, thank you. How much time is the appellant have, please?
Appellant has 5 minutes, 3 seconds remaining.
Counsel?
Thank you. I want to start with the question that you posed, Justice Cohen, which is that, let's say that the police had investigated after this report was made and determined that it wasn't supported by probable cause or that a crime didn't actually commit. What my colleague would have you believe is that even if the police found out that a complaint or a report to the police was false, even if that report led to someone's arrest and incarceration, that the person who made the report later confessed that she made it up, or it turned out that that was fabricated because of other evidence, my colleague would have you rule that even if she is prosecuted for perjury, even if she is prosecuted for false report to police, that her statement is nonetheless still covered by an absolute privilege. And the person who was put in jail and sat in jail while the police did their investigation into the false report has no recourse, has no remedy at all. That Article 4 of the Vermont Constitution offers nothing to them.
And Mr. Teachout, I don't want to derail you from where you're headed, but do you agree that if the court here finds an absolute privilege, that we need not reach any of the other issues?
No, and for two reasons. One is the absolute privilege this court has applied in the past has not extended as far as my colleague is asking you to extend it. It has never been extended to a conversation with a police officer when there's no court proceeding. The second reason it doesn't resolve all of the cases is because there's the anti-SLAPP component of this appeal, and Mr. Talandar was hit with a judgment for Ms. Manchester Murphy's attorney's fees because the statute says that she has the right to have him pay for her defense if he fails to meet this impossible burden that 12 BSA 1041 imposes. That's one of the reasons why Vermont's anti-SLAPP statute is unconstitutional. Another reason is because it shifts the burden to a plaintiff to prove their case by the highest possible standard. It's higher even than the standard in criminal cases, because in this case, Mr. Talandar had to prove the negative, which is that Ms. Manchester Murphy's statements were devoid in fact and in law. There is no other mechanism anywhere in Vermont law, anywhere else in our rules, anywhere else in the country that I could find, in which a defendant to a civil lawsuit can come into court and say, no, I didn't do it. And it shifts the burden, it throws the burden back on the plaintiff to prove their case by a standard almost twice as high as what they would need to prove to a jury if they ever reached that point. That's why Vermont's anti-SLAPP statute is unconstitutional. That's why Mr. Talandar cannot be penalized for exercising his attempt to seek a remedy in court for trying to regain some of his damages that he suffered when he was wrongfully imprisoned. I want to take a moment to acknowledge that I'm asking this court a very serious thing. And that is, I'm asking this court to uphold the rule of law and uphold a constitutional right in the face or in a way that is contrary to someone who claims to have been the victim of sexual and domestic violence. I'm not asking this court to take that lightly, and I don't take that lightly. It has been suggested that it is not appropriate to question whether a claim of sexual or domestic violence is true, and that the policy of protecting true victims of crime means that we should also protect absolutely those who make false reports. This is a court of law, and sometimes meaningful application of a constitutional right may be difficult or be contrary to the mainstream culture of the policy. But it is unhelpful to think about this as a sex assault rule, or think about this only in the context of an allegation or false allegation of sexual or domestic violence. These are broad legal principles, and your decision here today is going to extend far beyond the narrow kinds of claims that are presented by this particular case. Think about whether the rules that my colleague suggests to you work if you change the variables, whether it is still a just outcome. If I accuse my neighbor of beating her farm animals and she gets arrested and goes to jail and she loses all of her animals in a civil forfeiture proceeding, and it turns out that I made it all up, does she have a remedy against me? What does Article 4 say to her?
Okay, thanks.
I see that my time is up. Thank you very much for your time.
Thank you.